Appeals at section 20, at clause 23 of the bill. And that solution that I propose to you would be that we say that the consultation would be in writing and with reasons for the assignment to a new location in relation to the carrying out of the vending business. The reason why I propose that it would be in writing would be because there would be clarity in terms of evidence if you had to go towards an appeal by a vendor who is aggrieved at the decision, and the reasons would also be there for all to see, so that if in fact there was a vendor who is then aggrieved pursuant to Part 8, Clause 23, which deals with appeals, that person, in the same way that they can become aggrieved by a decision of the minister and appeal that, be aggrieved by the decision of the commission on vending and appeal that, be aggrieved by a decision of the manager of vending zones with respect to relocation or eviction, I think that they would have the benefit of having the reasons for the relocation in writing, and that would then enable an appellate tribunal to make a decision which will give teeth, as the Honorable Leader of the Opposition is, in my view, quite appropriately pointing us to in this matter. No, I just throw that out there for you all to mull over until when we come to that point. But if we do so, then Leader of the Opposition, I would ask that we could proceed from here and revert to that at another juncture. Are there any other, Minister Cummins?
Thank you, Chair. I just have one question specifically on the role of the, I just have one question in relation to the role of the oversight bodies that tend to represent the vendors. And so in this instance, we agreed in our first meeting that we would invite the representatives for vendors through Barven and any others. And I just wanted to see if, as in the case of entities like the social partnership, where you have the representative bodies as well as the individuals having an opportunity for consultations, if there's a role envisaged for such associations in this process.
For which associations, Minister? Oh, Barven, I believe, has been already invited.
I'm not referring to them being invited. Sorry. I'm speaking about the notion of consultation. If it is,
you mean consultation with respect to? Oh, I see what you're saying. Yeah. In other words, even though we're speaking about consultation with respect to the assignment of an individual, to have Barven involved in the process of the consultation. It is again, it is an interesting suggestion.
It's more a question of intent. Is that the intention?
Well, up to this point, it had not crossed my mind because I was seeing it more from the perspective of an individual's thing. But there is really no reason why we could not, and again, with a view to lending teeth to the consultative process, have the representative body, assuming that the vendor is party to that representative body, because all vendors are not necessarily members of Barven.
Chair, just to remember the orientation of this process, because it is really in the context of the person, the functionary granting the license, and also in the context of the manager of markets making certain decisions about allocation of sites, so that those functionaries do not, under this present construction, consult with anybody in making those decisions.
Chairman, I hear the legal drafter, but this is more a policy question, to be quite fair. At this point, when we're treating to questions of manufacturing, while we may consult with individual manufacturers, we do recognize the role played by the associations. And I could go on and on from tourism to small business and every other sector. And equally so, when we're treating to the questions of relocations and movement, we also typically consult en masse with the representative associations as well as the individuals. And from a policy perspective, I just wanted to be guided as to whether or not there may not be a role for the association in the consultative process, given the fact that in any event, if you are moving vendors from one site to a new location, you're typically not moving one person alone, but you are moving more than one person who may or may not be members of a representative body.
And I agree. I don't have any problem with that. I don't see any merit in resisting a wider input. So from my perspective, I'm in full agreement, Minister. My only other observation would be that even though the legislation does not speak specifically to this question, the appellate process, I would imagine, would enable the vendor who is appearing to be represented, and ordinarily that person would be represented by an attorney and or a friend. Is that not correct?
Yes, Chair.
And therefore, it would enable the vendor to have as his or her friend the representative of the overarching body, which would be Barvin, or any similar entity that represents vendors.
Chair.
I would support that as a policy measure, largely because, Mr. Chairman, I think we have to be fair to persons who are engaging in the appellate process or in the consultative process at the outset, and give them the best possible tools and resources, including their representatives, in the instance where they may need to use those resources. Because sometimes putting an individual vendor before a tribunal can be imposing, and I think we have to give them the benefit of support.
Mr. Chair. Mr. Chair, I just
Sorry. Go
well,
ahead.
I want to posit the view that the trade union should always be, especially if we are trying to create a new form of governance. Trade unions should always have the right to accompany any person who is a member of the trade union in areas of consultation, because, as we say, the word consultation could be subject to facing the complexities of trying to understand rights and duties and so on. And sometimes a worker or individual cannot really deal with those complexities. And I think that is the point that the Minister of Tourism was just trying to make. So, yes, I believe that some workers' associations, which might not be registered trade union movements, if a worker belongs to a workers' association, or if there's an individual attorney at law or an individual that the body considers to be more, I don't want to say able-bodied, but at least clever enough to be able to deal with these issues. I know it is sometimes for an ordinary man on the street to sit in a room with all the mahogany and people appearing to be esoteric in the language and frightening individuals and so on. And people say yes, ma'am, no, ma'am. All that time, the rights are within away from the individual. So I just like to see some provision in there so that that person who we are consulting with, which is that's where the problem really lies. What really is consultation? That they have an individual or institution to help support them when they have to be confronted with issues of this kind, called consultation.
Fine. Senator Wiggins?
Good morning and thank you, Mr. Chairman. We speak to the issue of the consultative process, whether or not vendors will have the right to bring a trade union, a lawyer, or a friend with them. But how does that sit in terms of we are looking at providing vending zones? If the government through this bill is looking at providing new vending zones for vendors, how does that conflict with the rights of those vendors in terms of, yes, we are going to have the consultative process with those vendors, but if we have determined that an area across the road from Waterford, the Bell Plantation, is going to be a vending zone, yet still you have some vendors who, let's say, want to sell corn along the ABC highway. Would you then have to still consult with those vendors who want to sell along the ABC highway, given that you now have created a vending zone, a large vending zone, let's say in the area of the Bell Plantation? Does that necessitate a consultative process in the way that I'm hearing described here? Or is it that once these vending zones are created, not that we are mandating, but I would think it is the cleanest process for all vendors essentially to move to that area? And as you know, I've spoken already about the vendors along the ABC highway, that if zones are created for them, that they should move. I don't think that they should be the back and forth in terms of arguing with them or their representatives whether or not they should move, unless of course they're operating from within their own curtilage, Mr. Chairman.
Senator Wiggins, I hear you, but I must respectfully disagree. I take the view that in all matters, it is desirable for us to have that exchange of views. I think the vendor must benefit from a clear understanding of what government's policy perspective is or policy intention. And equally, it is an informative exercise for the vendor to understand that if he or she is being relocated for whatever reason and being put in a vending zone, that this zone is constructed with a view to empowering and facilitating them and their business development. At the same time, on the other side of the coin, I think government benefits from hearing views that it may not have given thought to. For example, what we are doing right now as a result of the Leader of the Opposition's intervention. It does not mean, however, and I think this is where you're going, and in this regard, I want to give you the assurance that it would not mean that because we have engaged in the discussion that government cannot act and govern, because that is ultimately what government must do. It must at some point govern, but I don't see that there is any difficulty for us engaging in the conversation, getting the benefit of a cross-section of views, and then when the time comes for us to govern, we are better informed and I think better advised to take whatever steps are necessary. So that's just my take on the question you asked. I would say yes, we would be, I think, best advised to have the consultation on every level whenever it is necessary to relocate vendors.
Chair, just to speak generally in relation to the vending zones, just remember that Clause 13 provides that the minister shall consult with the National Vending Committee in terms of the designation of vending zones generally. The National Vending Committee, it has a number of members, including membership being represented by various
including Barbin.
Yes, including Barbin, so that it would include consultation with the vendors generally, should they decide to be a part of that process. So I just wanted to remind the committee of that provision. Thank you.
Grateful to you, Deputy Chief. So, if then I could try to capture where we are, I would suggest, Deputy Chief, that what you want to do at clause 17.3,
Chair,
Sorry.
just to make a recommendation,
go ahead.
you would have to include I'm going to use the language specifically if it was an act. So you would have to create another subsection dealing with the definition of consultation, and then set out all the parameters that we discussed, including the requirement for there to be consultation in writing with the appropriate functionaries, that there would be an appropriate time frame, and that there would be reasons.
Yes,
Yes, thank you.
fine. Are there any other requests for the floor on this point? I see none. Therefore, Deputy Chief, the floor is yours. You were at 17.3.
Chair, no, it's more now to move now to clause 18, because we would have gone
Oh,
through.
you've gone through
yeah,
all of them?
we've gone through all of them.
Okay, fine, no problem.
Yes, Chair, so.
And let me just make sure that all members are on the same page. And, does anyone have any other issues that they wish to raise under Part 5, Clause 17? There you go. Minister Cummings.
Thank you, Chairman. At clause 17.3D, I did have a note here on the question of reclaiming any merchandise which is seized pursuant to the eviction or the relocation notice. And I was noting here that prior to clause 17, there is no mention of that in the legislation, and perhaps it does come later. The mechanism on how it's being done, it does come later, but having made reference to it here, perhaps it needs a further clarification, because you see that up front without context, and it does create some angst in the minds of someone who may be reading it.
I sense, Minister, that
Yeah.
you're not to be faulted, because the practice of the law really is to, as you say, put it up front. And even though a level of angst might be created, you are invited to continue to read the legislation, and that angst will be settled.
Chair,
It
it's
is a-
basically to set out generally what the rights would be, and then the articulation in specifics will come later. So I don't think that there should be any
We're on the
problem,
same
because
page.
it sets out, it's unclear. You would have to use the arrangement of sections to inform how you go about understanding the legislation. So the normal tools of understanding legislation would apply. Thank you.
We're on the same page, Deputy Chief. What the part is attempting to do is to outline, in brief, if you will, what the rights are, and then they would be elaborated on as you go further into the body of the legislation. Could you then proceed to Clause 18, please?
Chair, Clause 18 speaks to general obligations of the vendor, so that just to speak to the circumstances in which they would be required to produce their license, circumstances in which they would be removing their merchandise in the conducting of their business, the requirement to maintain the cleanliness of the zone, keeping amenities and other public property in good condition, the requirement not to conduct themselves in a certain manner, including not using abusive language or insulting gestures or intimidating or harassing people, consuming or being under the influence of alcohol or drugs, or serving or distributing alcohol without the appropriate license, There's also the requirement to make sure that if you're engaging in sale of food, that you're in compliance with the health services for food hygiene regulations. If then you contravene those obligations, you will be subject to an administrative penalty. Thank you.
Thank you, Deputy Chief. Now, Clause 18, colleagues, are there any issues arising from that overview of the general obligations of vendors? Minister Cummings?
Yes, Mr. Chairman.
Oh, sorry. I beg your pardon, Senator Holder.
Yes, my hand was raised.
Yes, your hand was raised. The problem was not your hand, it was my eye. Senator Cummings had caught my eye, but I'm sensing that she is prepared to give way to you. So please proceed.
Thank you, Chair. Thank you, Senator Cummings. I wish, sir, to seek clarification on this word at section 18E3, consume. Some time ago, Chair, we talked about appreciating cultural realities and norms, etc. Is it that we are suggesting that the vendor, as we know is the case to be, may be invited to have a shandy, for example, I think has about 3 or 4% alcohol, with one of his or her consumers, guests? Are we saying that that vendor ought to deny the particular offer, and while in that arrangement not be able to have one drink with the shoppers, with the consumers there? Is that what we are suggesting by the use of the word consume? I understand that we are seeking to discourage vendors to be under the influence, intoxicated in any manner. We understand that and we totally agree. But, sir, is it that we should use the word consume? Should there be a synonym that maybe helps to get this point across?
Senator Holder, I am a bit perplexed, I confess. I think that you have both asked and answered the question. The only thing I could add is perhaps that, as in all things, there's going to be an element of discretion, but the intention is to avoid persons being under the influence of alcohol or drugs while engaged in the business of vending. I don't know that if I followed your analogy, that it would cause a market manager reasonably to intervene because he saw somebody sip a shandy. I mean, it is possible, but I don't know that that would be, again, you really have played, you bowled an unplayable ball.
It's very possible, Chair.
Senator Holder.
It's very possible, Chair. I mean, I'm not going to doubt the manager of markets, whoever he or she may be, and their capacity and competence and so on. But, you know, as much as we can, you know, give guidance through the legislation so that we avoid persons who may be prone to apply their own morality to situations.
Perhaps, Senator, you will help us considerably if you were able to propose an alternative, because again, this is linked. This in the event that this obligation was breached, the consequence would be to invite the vendor to pay or compel him or her to pay an administrative penalty. Now, again, the vendor has a right to challenge any administrative penalty that he or she feels is unreasonable. In the circumstances that you've outlined, were I a vendor, I certainly would challenge an administrative penalty of that nature. And therefore, while the vendor would be subjected to some form of inconvenience, and I suspect the manager market would be subjected to a level of public disapproval, I am not sure that the legislation itself can, unless you have an alternative, I'm not sure the legislation can account for the gray area that you're creating by way of your example. What we want to do is to avoid consuming certain types of things while in the business. Same principle applies, quite frankly, to those of us who are driving motor cars. We're not supposed to be consuming drugs or alcohol while driving a motor car. I am not aware of any case where a police officer has been successful because a man drove a shandy, drank a shandy.
But Chair, sorry, through you. I suspect in all things, the law, like all things, have to stand the test of reasonableness. And I do not know that any market manager, as it stands now, we do not allow people to consume beer while they work. And the reason that you stop the consumption of alcohol in the market is that these things escalate very quickly. And I think in the test of reasonableness, I cannot begin to imagine a person intervening for a shandy, to be truthful. I haven't seen it. But you do not want a case where you allow the consumption of alcohol on the premises. And in the Bridgetown market, for example, and in Oistins and in all of our markets, vendors understand that. And so when they want to have a beverage, they find themselves somewhere off the property. I think we do not want to encourage alcoholic consumption in the markets, in the vending zones, and so on. But I do not know that in this act, by the end of the day, that we're going to be able to reasonably put into the legislation or every single possible scenario. But you have to assume that the actor in this instance is a reasonable man. And so the law must, as we all know, stand that simple test of reasonableness.
Thank you very much, Minister Humphrey.
I would just like to suggest that I can understand if somebody becomes intoxicated. I can understand if somebody uses abusive language. But my little understanding of even case law, I have never seen a person charged for consuming alcohol. I have never seen it. I would like any lawyer to show me it. I would like a judge to show me it. I've never seen a man charged for consuming alcohol. You're charged for committing an offense. If you're not for drinking alcohol is not an offense. You'll be getting mixed up sometimes with class values, one, because many people drink alcohol on their jobs, but they can't drink alcohol and abuse persons or do anything that use obscene language, in any way reveal any forms of indecency, assault anybody. Those are the issues that the issue of tort will deal with, but there's nothing in tort, from my superficial understanding of the subject matter, that speaks to drinking alcohol. Ethics and morals and persuasion is something completely different. You can persuade a person, or you can tell a man you can't work here because you drink alcohol. You can't send him home for that. You can send him home if he gets drunk on the job or if he does something wrong. So I believe that this is an oversight. It is an oversight, and I think that we should hear the persons who drafted trying to find out exactly what it is that they were trying to address. And I think that the influence of alcohol or drugs although I believe it's not strong enough. But at least that is more explicit than to talk about consuming alcohol. I don't know, probably we need to hear the views of the lawyers present.
But this, before you go, Deputy Chief, we come to you. And I'm also going to come to you before I go to the Deputy Chief, Ms. Moore. But I I just want to assure you, Honourable Member, that before this came to Parliament, there were a number of meetings with the relevant executing departments of government. Remember, the Ministry of Commerce does not, the Department of Commerce does not execute any day-by-day governance over the activity of vending. That is dealt with either by the Ministry of the Blue Economy, it is dealt with by the Ministry of Agriculture, and equally by Ministry of the Environment. Now, in particular with respect to the fish markets and the other markets, it was made very clear by the respective supervisor manager and supervisor markets respectively that there have been instances, in fact, Minister Humphrey's terms just now were used by them, that things can escalate very quickly and have in the past escalated quickly, and therefore it is not desirable to have the drinking of alcohol or the consumption of alcohol or the use of drugs while intoxicating alcohol, intoxicating beverages, I want to be as clear as possible, or the consumption of drugs while in the process of vending. And while you speak about case law, Honourable Member, there are an abundance of cases under the criminal jurisdiction of the courts in Barbados, which begin with acts of violence being perpetrated in circumstances where, yes, but in circumstances where the parties, one or more, were intoxicated. And so what I think we are trying to do is to avoid that eventuality. And to be fair, though it is not desirable for, let me not say that. To be fair, I understand where your concern is, but I think that we would do well to hear from the manager of markets on this point when he comes. Can I ask us then to agree to hear the manager of markets and the supervisor of markets from fisheries when they come, so that the committee can be guided by the daily experience of those gentlemen who have to treat to these particular matters. I wouldn't want us to rush to judgment on this point without having had the benefit of wide consultation. Ms. Moore, the floor is yours.
Thank you. Related to the point, consumption of alcohol while vending, it took me to the definition of vending Act, Part 2, Section 3. For the purposes of this act, vending refers to the offering for sale of merchandise or the rendering of services in a vending zone for the purpose of earning a living or for the duration of a fair, farmer's market, etc. So I heard Minister Humphrey saying that what the practice, perhaps outlining what the practice is, that you step away from your station if you want to drink something. And I go to the definition and I'm thinking, if you're seen stepping away from your station, even if you're not at your station, the vending station, and you are consuming, it can bring the person in the example you raise similarly in breach of the law. So I'm just wondering if the intent and if what is actually there squares.
Yes, and honourable member, I chose my words carefully just now. And I'm going to say then now what I perhaps did not say then. There are some things that happen that ought not to happen. And we got to be mindful of those realities. And in all things, there's going to be the exercise of some discretion. There are those who, on the floor of the House, will be speaking after having had a beverage. That has happened. I've been around here for 20 years, so I know it has happened. And it is not something that one wants to encourage, but it is a reality. It's the same reality, and I don't want us to bring any artificial class barriers to it, because it's the same reality. People will leave a fish market, have a beverage, and come back. So the question of being under the influence really then becomes the question of your ability to tolerate that which you have ingested, right? But I think that what we are trying to achieve by this legislation, and remember, in a fish market, well, there's been one, two instances in the House as well, but in a fish market, you have people who are wielding swords, cutlasses, etc., as part of the tools of trade. We know that in Parliament, there have been instances where people have pulled weapons on each other. So the fact of the matter is that what we are touching on here is a reality of Barbadian life, whether it be the upper crust or at the root of the society. And what we have to deal with is to treat to that reality in a way that is sensitive to the culture, but at the same time making sure we bring order.
It's for that reason I raise it, because I agree with you 100%, and I wouldn't want that in the application of the definition, that everything you so eloquently described is used against a person.
Fine.
Who may be at a break, who may be at lunch.
Fine. And therefore, it may be best for us to take a little bit of guidance from the manager and supervisor of markets, respectively, who treat to these matters on a daily basis.
Chair, just to make absolutely clear, there is no creation of a criminal offense in relation to that conduct. It is Baker's, but it was put forward that the legislation was in fact creating it, and it was not. It is.
Sorry, that escaped me.
Right? It is not. It is that you would be, an administrative fine would be imposed. And then if it is that you have a problem with that, then you can appeal it. So I'm just pointing that out as a matter of clarification.
Point taken. Very grateful to you. Now, I have Senator Holder online who wishes to have the floor. Senator, the floor is yours.
Thank you again, Mr. Chair. I listened to the intervention from Minister Humphrey. He referred to reasonableness, and sir, while I understand that point, I still am of the view this bit of legislation here is not unique to markets. This is not unique to that demographic that he is referencing. And therefore, whatever we can do at this level to make sure that we are as general as possible in the language, I think, sir, ought to be contemplated. And so when Comrade Prescott intervened to suggest, well, let's hear from the drafters vis-a-vis, the meaning here, I was looking forward to that, because I don't think, Chair, that we can discount those occasional activities that will happen, the fairs and the entrepreneurial showcases and all these things that do occur. And I somehow feel that the word consume taken very literal may not be what we are intended here in the outcome and the spirit of the legislation, but we're really talking about, being under the influence, being intoxicated and the like. So could there be reconsideration, if you will, of a different concept, a different verb even, than the word consume? Because taken literally, sir, I don't think that is what is the spirit of the legislation.
Ms. Bell? You have a view on this observation by
Chair,
Senator?
I don't think that this is quite frankly, anything unusual in relation to how most professionals are required to operate. And so it is strange that you would raise something like this. However, I give way to the policy, and that if it is that consumption is a problem, then you can remove the word consumption and just deal with being under the influence of alcohol or drugs, and that can be done. So I'm just proffering that as an alternative. Thank you.
What I'm going to ask the committee to do then is to let us know where we are at clause 18, clause 18E3, and this matter of consumption or being under the influence of alcohol or drugs to be raised specifically with the supervisor and manager of markets respectively when they come. I believe that, interestingly enough, the police were to be invited to participate or to appear before the committee. Perhaps it should be raised with them too before the committee makes any determination as to where we go on this matter of consumption. Minister Ford and then Minister Cummings.
Yeah, thanks, Chair, and committee members. I just want to say that I think that you should just read consume. The consumption should not consume alcohol or drugs, because under the influence, in order for you to determine if somebody is under the influence, you will have to have either preference, you will have a person who's doing some type of test or something, because a person who may have maladaptive patterns of behavior may not be under the influence of drugs. The measures to control emotional moment. So it's just consume, should not consume alcohol or drugs, should be the right wording of the legislation, because we cannot determine by using what type of visual acuity we have that a person is under the influence of alcohol because of some maladaptive pattern or behavior that they exhibit. So to me, the legislation should just read should just speak to the consumption of alcohol or drugs, which is identified by a witness or something like that. If you see the person drinking or so.
Minister, I've heard you. I thank you for the intervention. I just caution you that while you're entitled to your view, the law very often is about precedent. The Road Traffic Act, I'm very sure, uses the language of driving under the influence. No. Again, there should have been, way back then, a way of testing it in the objective way that you have suggested. But that language has been around long before there were breathalyzer tests. So we can box ourselves into some difficult situations if we change the language too loosely. And I just want to caution on that. Minister Cummings.
Thank you, Chairman. I've listened to the submissions that have been made by the colleagues, and I'm sure that in each instance there is merit in the position being put forward. But I just want to caution, Chair, that while I understand the questions being raised about the intent of the legislation and the way in which it can be legitimately administered objectively, I just want to caution that we not go too far down this rabbit hole. Mr. Chairman, we live in a country, and I'm going away from the vending bill for a moment in order to come back to it. We live in a country, Mr. Chairman, where on every single day in the middle of a pandemic, we have our public health officials, our enforcement officials begging people to comply with regulations, seemingly to no avail, urging people to follow what is being asked of them, in this instance, to keep them safe and to keep everyone else safe. I think we have to be careful that we do not, in attempting to facilitate the normal cultural practices of our society and human behavior, that we don't create a society in legislation that is so permissive that there are no parameters within which people are required to function in what must still be a rules-based society. And so the question of consumption of alcoholic beverages on the job is not something that is unique to vending, but as was said by colleagues here, you don't typically have in legislation the permission being granted by way of its exclusion from your regulations, either administrative or legislative, the ability to consume alcoholic or otherwise intoxicating or behavioral altering products while on the job. If I leave my job and I go off to lunch or to dinner and I have a drink, as you have said has happened elsewhere, then that is one matter, Mr. Chairman. But I'm not certain that the legislative parameters within which we are framing a society to protect all would allow for us to remove consume from this legislation.
Thank you, Minister. I'm inclined to agree, and I would only add this much, colleagues, that I want us to think this thing through holistically. Before us also is a recommendation that we reduce the age at which one can vend illegally to 16. At the same time, we cannot have it being done in an environment, if it is a 16-year-old participating in vending, in an environment where, because we've just changed legislation to make vending legal, drinking of alcohol possible only at 18, so that legally possible at 18, so that there is a need for us to make sure that we bring the most holistic type of consideration to this matter. Minister, the floor is yours again.
Chair, I forgot to just make the point here that this section, along with clause 17 and 18, the two really have to be read together. And in furtherance of my earlier point, I think we stress a lot of our conversation on rights. But we have to balance that in all instances between rights and responsibilities, rights and obligations. And I think that the two clauses, rights at clause 17 and obligations at clause 18, really have to complement each other so people understand very clearly that yes, you are being given rights and you are entitled to those rights, but you are also obligated to have certain responsibilities which you must live up to. And that has to be the society that we help to frame in this country, Mr. President.
Not President, not President.
I'm sorry. I'm so used to a different person sitting in that chair, Mr. Chairman.
I just say this. Thank you very much, colleagues, for the interventions. Before we go to part 6, just for the benefit of the officers who have to take a record, we are using our language very loosely, and it can cause some challenges. It is preferable, because we are discussing a bill, for us to be speaking to clauses in the bill as opposed to sections. Sections are more appropriate for an act. And so therefore, I think we all understand what it is we're trying to say, but it needs to be properly said. And if it is not properly said in this place, we can't expect for language to be used well elsewhere. We have to set that standard for ourselves. Now, Deputy Chief, sorry.
I just want to make the point.
I beg your pardon, sorry.
Sorry.
Leader of the opposition did indicate that he wanted to have the
quite
floor.
some time ago, Mr. Chairman, thank you.
Don't do that to me,
and
man.
it has to do with the matter of administrative penalty for use of abusive language. That was more my concern than the consumption of alcohol, because consumption of alcohol, the degree to which you do that could affect your ability and bring the kind of dispositions that can cause all kinds of issues for others. But use of abusive language, I don't know that in average terms a Bajan can speak with either color or clarity without recourse to abusive language. This, we've heard it here. We've heard it here off the floor. Some of the most colorful language I've heard, Mr. Speaker, has been in the precincts of this Parliament. Some outside of the chamber and some in the chamber. I think you have been exposed to that as well. Quite concerned about us trying to address the matter of use of abusive language here. I've heard this used and this is not a class matter. I've heard this used all across classes in Barbados and all professions, trades. So it's not a market thing. I have heard this used among those in the clerical or ecclesiastical circles. Where I dispose myself that way, Mr. Speaker, I would have used some because you had me here waiting so very long to get your notice and attention.
I believe that the rules of the House still apply.
The rules, but they have been breached. They've been breached very often.
If you had been so inclined, you would therefore have to be censored.
I am not so inclined by nature, and not so inclined in this instance. But were I so inclined, I would have had just cause. I'm saying here that to me this is more likely to be observed as a breach. Well, administrative penalty for using colorful language.
Honorable Leader, I am not minded to say anything on that matter other than that there's a time and place for everything. And I think what we're trying to do is to make sure that those times and places are applied. Senator Wiggins, you had also indicated you wanted the floor. No, bear with me, Senator Wiggins. The honourable member for St. Michael East seems to have a challenge.
Yeah, I have a challenge because...
You're seeking the floor, sir?
They're seeking the floor.
But you must wait and call on Senator Wiggins first.
Okay, I'm quite willing to do that. Following traditional practices of ladies first.
There you go. Thank you. Thank you. Please proceed, ma'am.
Thank you, sir. I just wanted to ask a question that, generally speaking, when bills and so on are being introduced in Parliament, they're being introduced to correct a problem or to address a short-sightedness that has happened before. So the question, and Comrade Prescott could actually answer as well, is there a policy where there is a lot of alcohol being consumed with vendors, regardless of their location? Because this would have to have been put in there for a particular reason. So is there a precedent where there has been a lot of drug and alcohol use, as we would say, on the job? And if this legislation now is being introduced to correct that deficiency, or if we are looking towards the future? Thank you, sir.
The concern arises out of two things, as I understand it, Senator. I'm being very candid with you. In the preparation of the bill, it became clear that there had been a number of instances where, as Minister Humphrey said, things have gotten out of control very quickly when you have a very strenuous disagreement in some circumstances where people are working with implements that are capable of doing grievous bodily harm. So we have that backdrop. The second thing is that we are trying to lift this business of vending out of the confines of the criminal jurisdiction. In so doing, I think we also have to be mindful of the fact that we have to protect against those things that might lead unintentionally to the police once again having to have a role to play in this matter. Now, I think if we're frank for ourselves, we know that whether you're driving under the influence, whether you are in the House of Assembly under the influence, whether you are doing whatever, flying an aircraft under the influence, it very often leads to bad judgment, and then impaired judgment can lead to types of behavior that can cause challenges with the criminal law. So in reality, that is what was informing this consideration. You may, Minister Humphrey wants the floor. That does not compromise you. Honourable Member for St. Michael East is on the same point.
So I note the point raised by Senator Wiggins, and the truth is, in all the markets currently you see a sign saying no alcoholic beverages allowed. This has been the tradition. As a matter of fact, if you were to speak to the persons who work in the markets, for the most part, well over 90% of them do not wish to see any persons consuming alcohol or doing drugs in the market out of fear. So there is oftentimes a real fear among the women that when persons are consuming alcohol, they tend to behave in ways that would lead to all kinds of harm. So it is not only a new thing, it's something that we have been doing. But when the vendors come here, I am confident that they will represent the representative bodies, that they will say, because in my example, for example, Barnufo, which is the fish one, I know for a fact that they do not wish to see alcohol being consumed in the market. So it is not that we are imposing something against people against their will. What we are actually doing is reflecting the will of the majority of the persons who actually occupy the market.
Grateful to you. Thank you. Member for St. Michael East.
Sir, the law is not about what the majority of people wants to do or about if vendors agree to allow people to drink alcohol or anything like that. We're talking about a provision in law. You're talking about morals. We ain't talking about ethics. We're talking about law. You can't, I have never seen anything in law. This is a precedent, a small state precedent of a population left that it isn't a reflection of the general population. That is telling you now, if you consume, not get intoxicated, there's an effort here to try to mix intoxication and consuming alcohol. You want to tell me if somebody drink a small portion of alcohol, if that is wrong, it is morally wrong here and is also illegal here too. If at the highest office in the land, y'all can make available all different forms of alcohol. I drink some.
Honorable member.
Yeah, I drink some. But nobody can't tell me that I cannot come in here.
Is this working?
Because I drank it.
Is this working? Honorable member, can you hear me?
I'm speaking the truth.
You may well be, but honorable member, you can't. No, I'm never going to suggest that of you. The term creating an illegality. This bill will create no illegality.
No, but the fact that you can be penalized for doing it. A penalty is applied. It is not even perceived.
But you just heard the minister responsible for fisheries,
yes,
who has jurisdiction over every fish market in Barbados, saying that it is not allowed for you to be consuming alcohol in fish markets at present.
All I'm saying, we don't put certain things in legislation. You're not allowed to come to work late or mornings. But you don't make legislation to allow management to call in about it. So the law states this. It does not happen. I have never seen ice chem through the areas of law. I'm not an attorney, but at least I'm a qualified paralegal and I've been involved in working with attorneys at law. I have never seen anything in law.
Are you suggesting that, honorable member? I want to help you. Are you suggesting that Minister Humphrey's ministry, the Division of Fisheries, would just have meaningless signs up in the fish market saying you're not permitted to drink alcohol, but if you drink it, there's no penalty to be attached to the drinker? Is that what you're suggesting?
Because he's Minister of Fisheries, it does not mean that he has a right to preside over draft in the law.
No.
That's why we have...
Honorable member, we are not fighting. We're not being combative. I am just seeking guidance. Perhaps I could ask, if you pause a minute, hold your powder, keep your powder dry. Minister Humphrey, is there a penalty attached if I drink in the fish market as a vendor right now?
Sir, so what we do, because most people comply anyways, but people have to apply normally for a license at the end of the year. And these things are taken into consideration. Have you been compliant? Have you been causing problems? And so on and so forth. And these things add to the determination, of course.
So in real sense, go ahead.
We are making law. People can put up whatever signs they want to. The reason why lawyers get work is when lawyers recognize that what the individual administrator has done is wrong, we go before the court. It goes before the court as for civil action or criminal action in which the police will be directly involved. If I have been charged before in a court for entering onto the premises in the defense of young children at the Ministry of Education for trespassing, these broad generalizations make no sense. But nobody could, I can't remember the other term that they used, but nothing was written to explain what trespassing meant. So the case went through the window. All I'm saying is don't make laws that are ineffective. You charge a man for consuming. You charge a man for becoming intoxicated, using offensive language, inflicting some harm, or doing some wrong. You can't charge a person for consuming.
Honorable member, you may well be right. And all I've asked you to do, and I think that you had agreed prior to reopening the discussion, I thought you had agreed that we will wait until when the representatives from the Ministry of Agriculture and Ministry of Fisheries are here, so that we could get the benefit of their input.
Yeah.
You may well be right.
I would agree on that, but I would also like to suggest that from their perspective, that is all right, understand that concern, but persons who more, if the Solicitor General office is not giving us what we believe we ought to have here, I would like to invite somebody from the University of West Indies who deal with serious jurisprudence, right? Deal with the logic of these things, because in my view, this is devoid of logic in relation to the context in which it is applied. That is all I'm saying.
Honorable member, your point is taken. You've been heard clearly. But we're not going to take it out now. We're not troubling it now. We're going to have the benefit of some discussion on it before we take it.
I just want to say something before, Chair, with your permission. The reality is
Hold on a second. The honorable member is not yet finished, apparently. You finished now? Yes. Okay, good.
I just keep hearing arguments about, seems to be implying that if you drink alcohol, you're intoxicated. The chances are you're likely to do wrong. And I guess that's the reason why administrators would say do not drink alcohol on the job. But you don't carry a man. You don't have any strength to just say you drank alcohol. You just can carry a man to say you drank alcohol on the job. Well, you never see that yet. Well, I'm saying that other people drink alcohol.
There's merit in your argument, I'm just asking you to keep your powder dry. We will come back to this. Minister Ford, the floor is yours.
I just want to say that we can always deal with the consequences and if a person should be charged and what the charges and all those things can be dealt with after. But the reality is that the Minister of the Maritime Affairs, he understands the environment, and his people understand the environment that they operate. Oftentimes they go in the fish market, and worst thing that's crossed my mind is if these guys get in the noise, with all those swords and sharp knives and things around. I think that in the same way that I want to expect people to go out in front of school and be selling jello shots or any type of alcoholic beverage, and any other place that we got weapons, or you understand the sensitivity of the environment that you are in. And I think that that's where we have to look at, maybe look at the legislation. The same signs goes up in the Ministry of the Environment in terms of no alcohol, and there's a reason for it. You have to understand the situation, the circumstances, and the environment that you're in when you're making these decisions. And that's all I want to say.
Thank you, Minister. Minister Humphrey?
So, Chair, I just looked at the Market and Slaughterhouses regulations, which are currently guide. We abide by the Market and Slaughterhouse Act. The definition for intoxicating beverages is given there. It says the term given in the reg, so this is not new. Intoxicating liquor has a meaning assigned in the Liquor Licenses Act. So that is defined somewhere. They go on very clearly, this act is old. And they go on to state that no person shall consume, this is in the original act, intoxicating liquor while in the market. So I don't know that this is new, or that we now have to go and find a university lecturer to tell us what intoxicating liquor. I mean, seriously, because I know the minister is not, the honorable member is not attacking me, but I'm just saying there's a reason that I believe the architects of this original legislation put these things in, and the reality is, I am thinking of the markets in which I spend a lot of time, sir. So it says no person in any public market shall sell, consume, or otherwise dispose of intoxicating liquor. So it is already here. And we are not adding something new or changing the legislation to penalize persons, sir. And I don't know then that it is fair to say that this is the first time it has been in any legislation, because it is in the 1958 legislation.
Chair, I have to reinforce the point. I'm not saying there's a problem with intoxication. Apartheid was law. Apartheid was law years ago. But it was not justice. It was not right. They we come to Parliament on a regular basis for amendments to the law, because the law is not fixed. From time to time, we change the law when we observe that there are things in the law that ought not to be there. So to tell me that the law existed since 19-something and 20-something doesn't mean we've got laws that exist in 16-something that we're dealing with in Barbados
Sure,
at
except
present.
the only reason I mentioned that is because the honorable member is the one who did say that it doesn't exist in any law. So I was just saying that it does exist in the previous
Well,
law.
you like to believe you're a modern thinker.
Gentlemen, we are not going to debate this particular point any further. I think that we are going to move on, and when we have the benefit of hearing from the supervisor of markets and the manager of markets respectively, we will then revisit this issue. I think all the views on the matter have been made. Is there, okay,
On the clause.
on the what?
On clause 18 generally?
On clause 18 generally, yes. You wish to have another intervention?
I
Please
do.
proceed, Minister.
Chairman, I had two queries on clause 18. The first one is at clause 18.1, and the second is at clause 18.1C. So I'll start with clause 18.1, and it says here, produce his license for inspection when requested to do so, and it speaks to the customer. And I just wanted to get a sense from the drafters, this is more the legal question. The precedent exists when you walk into a physical store that your licenses are displayed. Equally so in things like public transportation, they're also displayed. And I wanted to get a sense of whether or not there needed to be there was a reason for persons being required to produce rather than to display their license for inspection. And in that's the first query. And the second one is in terms of 18.1C, maintain the cleanliness of the vending zone. Chairman, again, going back to that question of obligations and rights, we do have some issues with areas being left in an unkempt and an untidy state for an extended period of time. And I wanted to know if whether or not it was intent, perhaps by the addition of administrative regulations, or if you wanted to put it in the legislation itself, the primary legislation, to include a time frame within which cleaning the space had to be done. So, for example, in the Ministry of Health, we're navigating presently the dengue issues, and leaving coconut shells on the roadside and accumulating water, especially in rainy season, becomes a problem over an extended period of time. Is it intended as a policy measure for us to have a time frame within which cleaning and the removal of debris should be undertaken at clause 18.1C? Those are my two queries, Chair.
Let's just deal with the last one first. At part 10, under miscellaneous provisions in this piece of legislation, the minister may make, at clause 34, may make regulations generally to give effect to this act. It is the intention of this minister that that particular matter of the cleanliness of the vending zone will be addressed in the regulations, and yes, with respect to the considerations of time. I defer to the Deputy Chief Parliamentary Counsel on clause 18.1A, display of a license, ma'am.
Chair. Sorry about that. Chair, that was simply instructions and nothing more.
But to say that is to only reflect on the instructions. I think that there's merit in the view that we should be able to have vendors display licenses wherever possible up front. In the event it is not displayed, then perhaps you can have them being requested to do so. But I see no reason why we should not have or encourage vendors to display their licenses up front.
Chair, the obligation on request to do so already exists, so it's just to put in the display aspect. The question to some extent of the practicality in some circumstances where you're selling, that may have informed the policy, but I'm not sure, so I would have to get to it.
Sorry, Chair, like in a market, you might have 4 or 5 persons in a stall. There's really very little space to be able to display
A license.
a license. And then there's hardly any upright. It's difficult. In the fish market, for sure, it would be very difficult to display. That's why you would say, show me when you're asked.
All right, fair enough. That seemed to be a reasonable answer to me. Minister, that satisfies you?
It does in principle, Chair. I have no objection. I think the practicality is a real concern. That's not to say that we could not, in the same way, establish single standing signs or something that would allow for persons to have their things displayed, not on concrete columns necessarily, but it could be something as simple as a stand so people can be displayed. I think if we're professionalizing the sector, that I would want us to go all the way and to give it the professionalism that it deserves.
Sorry, Chair, the point is taken.
Okay. Then we can proceed, please, Deputy Chief, to Part 6, relocation and eviction of vendors. This is the pith and substance of the legislation, so I expect that it will. I expect that it will draw the interest of the members of the subcommittee. Part 6, ma'am.
Chair, clause 19 speaks to the relocation or eviction of vendors. It's a clause 19.1 speaks to the reiteration that there shall be no relocation or eviction of vendors without there being 30 days notice given by the manager of vending zones. Manager of vending zones has to do this by notice. The nature of the notice then, the form of the notice is in the schedules to the legislation, fish schedule namely, and yes, so, and then
Fifth schedule, Part 3 and Part 4.
Yes, Chair. In issuing the notice, there has to be some stipulation about the nature, and there's a recital of what would constitute the breach, including whether there was a breach of the condition of the license or there was a breach of an enactment. There's also whether there was a suspension or a revocation, whether there was an emergency or whether there was a public safety element. As stated before, the 30-day notice will be waived where there's an emergency or other circumstances as stipulated in the public safety, public order, or public health. And where there is a requirement for assistance, then the manager of markets has the discretion to ask for the assistance of the police if necessary. So I invite comments in relation to Clause 19.
Colleagues, floor is yours. Clause 19. Subclauses 1 through 5.
Chair, again, I think that this also brings into contention the causalities that would allow a manager to be able to exercise certain rights in terms of what would allow him. What are the things that would allow him to take such action as to evict? Because when I hear evict, it says something. I can understand if he's not honoring his payments, his contractual relationships, or anything like that. He can be evicted. A man can also abuse the right to move a man from one location to another. In other words, I've heard about instances sometimes where people working in the civil service, for example, this might be an extreme point, but sometimes senior officers are not pleased with the person, and you try to you abandon them, set them in exile down in St. Lucie as close to the cement plant as possible. So you move them from Bridgetown, send them to the cement plant, knowing that they live in St. Philip, all of that. So we have to think through these things when we do them, because you have people that are very subjective in their approaches, and they sometimes could do things that they believe give them some inner satisfaction. And I don't want to describe that behavior, but I think we have to look at it, especially when we're talking about evicting persons, and the word relocation almost could be synonymous with evicting if somebody is very sinister in the approach to resolving administrative problems. So,
Chair?
is there anything that you have here which I have not seen or probably saw but do not understand, that you can point to give me some idea of what are the responsibilities of a manager in relation to what will give him the authority to relocate or to evict an individual, or is that unnecessary in terms of legislation?
Chair, just to point to clause 19.2, which speaks to the grounds where the vendor is in serious breach of a condition of his license or in breach of the act itself, any regulations made thereunder, or any other relevant enactment, where there was a suspension or revocation of the license, where there's an emergency, and when there is a danger to public health, public order, or public safety. In addition, if it is that the vendor is aggrieved by a decision of the market of manager of vending zones, then he may appeal that decision under clause 23. And so the required mechanism for protection is in place. The manager must operate within the scheme of the legislation, but the legislation also provides for redress if the decision aggrieves the vendor. Thank you.
Thank you, Deputy Chief. Are there any other requests for the floor on this?
I just want to go a little further. Then the tenants that influence the manner in which management carries out its responsibility must be unequivocally clear. And that's why we're saying that loose generalizations would not work. We don't want to make the work of the judiciary hard. We try to at least draft the law in a very detailed way so that we don't have to wait until a judge or even a magistrate preside over matters of this kind, and then he has to spend a couple of days before he can really understand what the legislation intended. So it is an imperative that everything here must come on it, detailed analysis, so that we can make sure we do not pass on all kind of ambiguities to the judiciary, waiting for them then to tell us what the interpretation of the law. And as I said before, we have had those experiences here, even in this government at present. We have had those experiences here where small matters, when they appear to be small matters, but then we discover that a major decision had to be made at the level of the judiciary. So I'm just urging, I'm not pointing out any specific aspect of it, the importance of ensuring that we get this right before it gets itself past the accent of the Governor General.
Honorable Member, I have heard you clearly. Is there any specific area of generality that you wish to point the committee to in this regard? Or are you just issuing a warning to us?
I'm just trying to give primary guidance, if I'm so qualified to do. And I'm saying that this, what we are talking about here, is not disconnected some of the things that we were talking about earlier in section 5. So
agreed.
I'm just
I've taken it on board. I was just wondering whether there was a specific instance that you wanted to draw attention to. But noted. I see online Senator Hunt seeking the floor. The floor is yours.
Thank you, Chair. I see that there's reference to the penalties that a vendor who is considered to be in serious breach of conditions of his license that he can face. I do not remember seeing, so this is therefore more so a request to be pointed in the right direction. But I don't remember seeing guidance in the earlier parts of the legislation where we can be comfortable that the manager of vending zones, who has the authority to effect evictions or relocations, that he's provided with a way to determine a serious breach, or should you say a minor breach on the other hand. I'm concerned that if there is just reference to what can be done in the case of a serious breach, that may introduce a measure of arbitrariness in legislation that we would be best not to have to do. And I think it may allay some of the fears raised by the previous speaker.
Thank you, Senator. Deputy Chief, I'm inclined to hear you on this. I would have thought that, as with most things of this nature, when once a person feels aggrieved and has been provided with reason for taking that position of being aggrieved, then they go by way of appeal to the powers that will make a determination as to whether or not the administrative act was reasonable or otherwise. But I'm guided. I can be guided.
Yeah. Chair, there is a mechanism by way of appeal under Part 8, starting with Clause 23, about any decision made by a functionary in relation to decisions that are made, so that an appeal can be made. And if it is that they are aggrieved by a decision of the tribunal, you can further appeal it in the High Court. That is made provision for in the legislation as well. I can take the point about the serious breach, the language, but the thing is then The only real thing would be the taking out of the word serious breach. The fact of the matter is that you want to be able to have an recognition and an understanding that the vendor must comply with the conditions of his license and the provisions of any enactment as any other person who is operating within a scheme would be required to do. Thank you.
I'm inclined towards agreement with Senator Hunt, as I understand his submission, that the word serious may well be, not his language, but mine, may well introduce an element of what is the term I'm looking for? Subjective and discretionary, arbitrary and discretionary thinking here. Either you're in breach or you're not in breach. There's a penalty for being in breach. If we get into the realm of what is serious breach or not so serious breach and so on, that allows for some arbitrary and discretionary wiggle room, which might not be helpful in public administrative law. So I am thinking that, therefore, what we probably should be doing is taking out the term serious here, because the seriousness of one issue may not be serious for my successor, in which case we will have it varying with the size of the manager of vending zone's shoe. As one manager of vending zones comes, something is serious. When he goes, it is no longer serious. It may best be that if you are in breach, then you are in breach of a condition of your license, provisions of the Act, regulations made thereunder, vending without a license, emergency within the meaning of Section 2 of the Emergency Management Act, or being circumstances where there's a danger to public safety. And with those areas clearly and certainly defined, then we are better positioned.
Yes, Chair. So the word serious will be removed. Thank you.
Okay. So the thinking then, Senator Hunt, thank you, would be that we would remove serious from the language of the legislation. And it would simply be that a vendor is in breach of a condition of his license. Thereafter, all the normal considerations of public administrative law would apply, and your appeal process outlined already in the Act would follow. Good?
Yes, sir, that is satisfactory.
Okay, fine. Any other concerns or issues being raised under Clause 19? There being none, we move to Clause 20, seizing and reclaiming of goods.
Chair, moving on to Clause 20. Clause 20 seeks to set out the procedure for seizing and reclaiming of goods, so that when there's a failure to vacate pursuant to Clause 18, the manager of vending zones may seize the merchandise of the vendor. And where there is a seizure or proposal to seize, then there must be an issue of a seizure notice, the form of which is set out in the fifth schedule. The particulars set out in the notice would be the time the merchandise was seized, the location, the list of the merchandise seized, and the description of the items seized, including quantity, weight, size, condition, and other descriptor that the manager of vending zone determines as relevant, and also then the procedure for reclaiming the merchandise. There was also obligation to seek the assistance of a member of the police force where necessary. The vendor also shall seek to reclaim the merchandise seized within 24 hours of the receipt, and will comply with the procedure for reclaiming the merchandise as set out in the notice. The where the merchandise is subject to the seizure notice, is non-perishable, then the manager of market zone shall release the merchandise to the vendor within 2 working days, and where it is perishable, they shall release the merchandise immediately to the vendor on receipt of claim from the vendor. The vendor shall be compensated for loss in certain circumstances under C and D of section 19.2, but the compensation shall not exceed the value of the merchandise seized, and that had to do with the extraordinary measures there, which were the emergency, and where there is no claim for the merchandise seized, then the manager of markets will have the discretion to sell the merchandise, and if the sale cannot be conducted, then dispose of it in the appropriate manner, and the proceeds of sale will be paid into the consolidated fund. So, comments in relation to clause 20. Thank you.
Colleagues, floor is open. I see Senator Minister Cummins.
Thank you, Chair. I did have a query and a comment, but the comment would come perhaps in response to based on the response to the query. So at section 21, if the vendor fails to vacate the vending zone, this is within the 30 days notice which would have been given under clause 18, and the specifics contained therein. Then clause 22A would step in, where there's a seizure notice. Is it the contemplation of the legislation?
Clause 20, subclause 2.
20, subclause 2A, yes. Right. Is it the contemplation of the legislation that if the 30 days have elapsed and the vendor then is being issued with a seizure notice, that the seizure notice is being given after the seizure of the goods, or is it that the seizure notice is the final notification that you must now within a scale of time frame? So you had 30 days before. And let me just try to simplify this because I think I'm confusing even myself. But if I have a notice that I must move, and I have 30 days within which to do so, I don't do so, and then I'm being given a seizure notice, is it that I have until the end of that, let's say a 24-hour period before the seizure is going to be effected? Or is it that my goods are going to be seized immediately and then I'm issued with a seizure notice and I have the opportunity to reclaim?
So Chair, it is supposed to be that if you don't comply with the period, then the manager of vending zones will issue the seizure notice. So that's how it's supposed to work. The other thing is that it is contemplated that there would be regulations to flesh it out more, but on its face, it would be that upon the elapse of the period, then you would issue the notice.
Chairman, that was my reading of the legislation as well. And I just wanted to, in the spirit of the discussions around the legislation itself, perhaps the prerogative of mercy is something that I think we have fought for in other pieces of legislation. And I'm just making the point here, Mr. Chairman, that perhaps if the 30 days have gone and on the morning of the 31st day, the person has not yet moved, the seizure notice could contemplate telling that person, if by the end of the business day today, 24 hours, you are now on the day of the 29th or the 30th day, you are about to be in breach. If these are not removed, this is what is going to kick in, so that people understand that they have a last chance within which they must comply. And I'm just suggesting that rather than after the fact, that we do it before the fact and give people an opportunity to avoid having their goods seized. And I say that only because, Mr. President, sometimes, Mr. Chair, I'm so sorry, Mr. Chairman, sometimes people's failure to comply is not necessarily just a refusal. It's about that which is outlined in the basis of this legislation, earning a livelihood and making a living. And so if people don't have an alternative as to where they're going to go and how they're going to support their families, them remaining in a given place may not be because they don't want to comply. It may simply be that they don't feel as if they have an alternative. And I just wanted to make sure that we were not too draconian, even though we are decriminalizing this. And I would like to be able to see persons have at least one last chance within day 30 to 31 to say, I want to avoid my goods being seized by the end of this business day, and the seizure notice take into account that time frame.
Is this the same Minister Cummings who just warned us that we have to be guarded against the permissive society?
It is, Mr. Chairman, and so context matters. And I'm saying that you have a framework here that allows for grace. And so the grace is 30 days. You have a set time frame. And what I am suggesting is that by the time that time frame has elapsed, I would not want to have a person on day 31 say, I didn't realize that the time went so fast. Let them have the seizure notice on day 30 to say, if you don't pick this up and you don't move by the time frame, you are going to have your goods seized. And that may be the impetus.
Effectively, Minister, you'll be giving them you'll be giving them not an extra day, but you'll be giving them a day's notice that this is what is about to happen. The seizure is about to take place.
Yes, that's all I'm making. I'm not turning back the clock for the 30 days. I'm just saying that you have now issued the relocation notice already. And before you issue the seizure notice, it should be before and not after the fact.
Mr. Chair, I think that there's also a practice in the, sometimes the court gives, I'm not sure, I think this is something that we need to think about. The court gives notice to remove a house within a specific amount of days. So you should remove the house within the days stipulated. But then I understand that the onus is also upon those who are supposed to execute to remove it within a given time, and if they don't, then they have to go back through the process over again. So if at any time you notify a person that within 30 days you must do A, B, and C, the onus also has to be placed on you that you must take action within the next 5 days or not. If that time expires, that is nothing to do with the person who must be removed, the vendor, right? But the person, the manager, the enforcer, right, also ought to have a certain amount of time, limited time, to execute the decision. And if it does not, he has to go back through the process, so the vendor might end up being there for the next 3 years. He has to do his work right. But you see, I'm trying to get away from all of these burdens falling on the vendors to honor agreements.
I'm sorry, Minister. Sorry, Honourable Member. That last point eluded me. I must confess.
But you didn't
it may be my difficulty.
My poor way of explaining myself.
You're usually very clear.
I thought we were.
I am prepared to accept responsibility.
I believe the Minister of Tourism
I did, Chair.
The leader, the Baptist Workers Union, in these circumstances, and we hope that's from where she speaks, they both would probably be able to articulate that. That'd be a lot more lucid than I am.
Just restate your submission.
All I'm saying that the burden is placed on the vendor to move within a given period, 30 days.
Right.
But I also believe a responsibility must be placed on management to execute his responsibilities within a given time. If that time expires, then he knows very well that he has to go back through the entire process again and send out a fresh notice, giving the person another 30 days in order to take action.
Chairman,
Sir, my brain is at a point where I am not a top-down approach. I'm not a top-down There's no well diggers inside here, and everybody seems to be
inside this committee, honorable member. I cannot allow you to.
I
cannot allow you to disparage honorable members of the committee.
No, I'm not. I'm not. Probably might be observers. So I'm just saying that going back again to probably an area that people heard me express my views about. There's a lot of pro-colonial thoughts going on, and these laws that we're talking about was designed before many of us had any authority to say anything about the law, no more than being critical of it. Now that we have an opportunity, I don't want us to be absolutely guided by what people did before. I want to know what is it that we can do now, at least to take some of the burden. If we're talking about decriminalizing, even we got to be very careful that we don't become regimental. So you might decriminalize, but then you become regimental. For me, regimental is equally as evil as criminalizing. So I'd say that put some emphasis on the role that management must play as well. Management must not be perceived in these discussions as dominant paragons of virtue. We come out of a history where management was always very sinister. I'm saying that that cannot be our approach. So if a manager, he or she is going to say 30 days notice for you, I want to know how much days we are going to, the limitation we are going to put on him, rather than leaving the man there every day worrying about if he's coming today or tomorrow. The man will know that 5 days passed and he did not execute. The man has a right as well to put up a defense.
And therein, honorable member,
Yeah.
lies my challenge with both your submission and that of the honorable senator who spoke before you, the Minister of Tourism. Part 2 of the 5th schedule, for those who have it in hard copy at page 59, speaks to the eviction notice. I want to remind honorable members that the eviction notice must come 30 days before the eviction takes place. And that eviction notice says that due to, and you state the reason, the manager of vending zones has determined that it is necessary to evict you. For argument's sake, I insert the name Mr. Trevor Prescott, vending license number 123, engaged in type of vending from vending zone, wherever that is. This notice shall be effective at the end of the 30-day period after the date of service on the vendor. So you know, for the purposes of the Honorable Minister of Tourism, that the notice, if you got it on the 1st of October, it's 30 days later that this notice becomes effective. I'm not sure then why the state has to issue you a reminder, having issued you a notice that contains all the necessary information. And my question therefore would be, does that not place an undue burden on the state administratively? Then now with respect to you, Honorable Member for St. Michael East, you lament the fact that management does not do things in a manner that is timely, but it is the legislation that immediately after that 30 days expires that Part 5 seizure notice cuts in, when the manager of the vending zone has to issue you the seizure notice. Now, I don't know that it is practical to expect that in every case, 1 day after the 30th day, you're going to get the seizure notice put in your hand. It may well be that that can't happen until 2 days after the 30th day. Or in circumstances where we may have had something happen on the island, whatever, it may take 3 days to get to you. But the point is, do we need to prescribe a time frame within which yacht season notice is put in your hand, when the vendor now, and I go back to Minister Cummins' point about not wanting an overly permissive society, the vendor has been placed on notice that he or she, within 30 days of receipt of that notice, is going to be liable to have their goods seized. So you exercise good judgment and prudence and common sense. Do I need to wait for a man to come and hold my goods? Or do I begin to take steps from day one to put those goods in such condition that they can be looked after appropriately, rather than wait for the 30th day or the 31st, 32nd, 33rd day when the man come and seize them? So I'm not sure that we are, I don't want to say the arguments are not substantive, but the substance is eluding me.
Mr. Chairman, if I may respond, and I may have to, I would not attempt, Chairman, to assert any real knowledge of the law. I am not an attorney, so I can't say what is normal in course of the law, but I do know of several instances, Mr. Chairman, whether it is an eviction notice where you are given notice to vacate premises. When that period of time has passed, you are then served. If it is in the case of the environmental protection and environmental health regulations, Mr. Chairman, if you are being required to remove, say, a vehicle, an old vehicle from a location, you are served with a notice and a time period within which it has to be done, and then you are served thereafter with a notice that it is going to be moved because you have not complied. And I'm just speaking of this particular legislation in the context of those two examples, where after you have been given notice, you are then told this is the enforcement action that is going to be taken, and you are given a reasonable opportunity in this instance, whether it is on the 30th or the 31st day, to comply with this. Otherwise, this action is going to be taken. And that is the basis on which I was making a recommendation. But equally so, I agree with the point being made by the member from St. Michael East, and the clause at part 3, where we were speaking about licensing requirements and so on. We agreed, and I understand it as a matter of principle, not specific to a clause, but to legislation and policy making generally, that there had to also be a set of standard operating procedures that then created an obligation on the state to turn these things around in a reasonable time frame. So if you have served a person with an eviction notice, and the 30 days have elapsed, and you notify them, yes, that there is about to be action taken against you because you have not complied with this notice, as is the case with the two examples that I gave previously, then the responsibility on the state is to act within X period of prescribed time as a standard operating procedure, so that you do not have a scenario where things fall through the cracks in the system and a person remains in a location from which they have been evicted for 3 years, as has been mentioned by the honorable member for St. Michael East. It is a matter of ensuring that there is completeness of the circle and follow through both on the part of the vendor and on the part of the state within reasonable and predictable timeframes.
I just want to hasten, though, to point out that the honourable members for St. Michael East used that 3-year period very arbitrarily. I do not know that's rooted in fact. I am prepared to hear all the honourable members. Minister Ford caught my eye, and then the honourable member for St. George North. No, he insists that ladies go first, so he...
Chair, I was just going to say, in addition, not alternative to, in addition to what Senator Cummins just mentioned, we agreed at clause 17, when we were examining clause 17(3)(b) and C, that we would look at establishing time frames, and I think that this is where the honorable member for St. Michael East was going to, in terms of taking the burden, shifting the burden away from the vendor alone. And if time frames are instituted to address 17(3)(b) and C in terms of the consultation and the assignment to a new location, if these time frames are not met, then the process, the 30-day process, in a sense, is null and void, and we have to look at it all over again, start the process all over again. So I think in addition to what is being said, that if we institute timeframes beyond the 30 days at A, and at B and C, those timeframes that we agreed that we will look at for consultations and assignment to new locations, if those are not met, then the whole 30-day notice period that we're looking at will have to be revisited.
But with great respect, honorable members, I would like to hear your thinking, because we're shaping policy. I just want to hear your thinking on this matter. If you go back to clause 19, subclause 2, A, B, C, etc. We are trying, as I understand it, you are looking to place an element of responsibility on the state to move swiftly or within a defined period of time in circumstances where the vendor is in breach either of the conditions of his license, he's in breach of the provisions of the Act or any regulations made thereunder, or alternatively is in breach of any other relevant enactment, or that the vendor is in breach of his vending license, his vending license has been suspended or revoked, or there's an emergency within the meaning of the Emergency Management Act, or there's a danger to public safety, public order, and public health. My question is, what is the policy benefit to trying so strenuously to find a way to set this process back, dial it back to the start, to begin it all over again, in circumstances where the action being taken is one in which the responsibility or the obligation of the vendor has been violated and he or she is in breach, and worse yet, might be in circumstances that are conflicting with public health, public safety, or public order, or a public emergency. I threw that out, but the honorable members to whom I threw it out have fled the scene.
I don't mind, but
Only the member for St. George North remains.
yeah, and I don't mind taking it up, because my concern might be a lack of my own understanding, because when we look at clause 17.3, it speaks about a 30 days notice period before the imposition of a relocation notice. It goes on to speak about consultation. So my understanding is that this might be a charge being brought against a person, but not necessarily proved. Otherwise, why would you be consulting, etc.? So it is not an attempt to set the clock back. It is rather an attempt to make sure that the process is tight, so that if the state then is issuing, is putting in place this 30-day notice before the imposition of a relocation notice, is going further to ensure that everything else is airtight, so that you don't have to start the process all over again, but you can proceed along the lines that you have so determined, if you're so convinced that the person is definitely in violation of of their license and the other provisions. You want to keep the process tight and not restrict the onus to being on the vendor alone, but also on the state.
I'm here. I'm seeing the honorable member for Christchurch West Central.
Yeah. I just want to say, Chair, and I suspect that is where you were trying to carry us in terms of the discussion. But as the minister who sits in the fulcrum of these types of bills, vending, whether it is Ministry of Environment, whatever, I think that if I sit down and tell you all the issues that we have as it relates to, especially in these dire economic circumstances, the issues that we have as it relates to payments, as it relates to subletting, as it relates to all the other issues associated, with idiosyncrasies in this type of arena. I think we have to govern, we have to manage. And I really think before it gets to this stage where we are speaking about any legislation, there is an exhaustive process of consultation. I can say that from my ministry perspective. There's an exhaustive process where the vendor is given the opportunity to make amends. So before it gets to this stage, even serving notice 30 days or even an extended notice to quit or whatever, there is an exhaustive process that goes on. There's a process where persons come in and they make certain arrangements to pay off or whatever. So I'm saying before it gets to this, there is a lot of dialogue and exchange between vendor and manager, and then the situation is they're given a chance to make things amenable. And I think that this is the end stage of a long, exhaustive marathon. And I don't know if there's any other way that we can do it other than to just manage the process. Because without this type of legislation, I wouldn't be able to manage anything at the NECC, the honest truth.
And I think that you may only add injury to an already difficult set of circumstances, if you were to say that you now dial it back by another 30 days. Bear in mind, and I want honorable members to be mindful of this, we are going where none others have gone before. This idea of 30 days notice is unprecedented. Effectively now you would be saying, well, instead of 30 days, you shift the burden onto the state that they must act within 3 or 4 days of that 30 days, otherwise you got to take 60 days, which really makes the governance of the situation, it was wrong because it was problematical because it was not fair. The playing field was tilted completely against the vending community. Now we'd be asking for the playing field to be tilted completely in the opposite direction, which I don't think is what, in my judgment, we want. I think we want to have a more balanced thing where people are mindful of a certain responsibility. And when I go back to the notice that is given, the notice that you're put on notice that within 30 days your goods are liable to be seized. That is a period of time within which you can make amends or seek so to do. If you have not made amends or sought so to do, then the eviction cuts in. And I'm not clear what the benefit would be, either to the vending community or to the state, if we were to say now, well, on top of all of that latitude, you can go back to start the process all over again.
I think, Chair, that you are speaking solely in terms of, or if you examine it in terms of an eviction notice only, one may be inclined to see it the way you do, but I think my contribution looked at it being a relocation, because this section speaks to relocation or eviction. And in relocation circumstances, ensuring that the site and so on, the new site that you're going to be allocated is suitable and so on, my contribution took into consideration that if those discussions are not made in good time, then to proceed to seize and all these other things, they may not lend to the kind of thinking that I thought we agreed to when we said that we would establish time frames at 17B and C. For instance, if then it is a relocation and not an eviction notice that we are considering, and on day 29, the individual is being told, I can send you to Solidarity House, then that is not deemed by the individual as a suitable alternative location. What that person then has is just an additional day to scramble about, move the things. They don't have the opportunity to rebut, consult in a meaningful way for anything to be done. So I'm just saying, or the contribution just seeks to have us establish those time frames, not to restart the process at day 31, but to ensure that in the course of the 30-day period, there's also a responsibility on the state to follow through on certain things to ensure that the area that we have gone where no other people have gone before, that it really meets the objective that we've set out for it to achieve when we looked at putting it in place.
As the honorable member for St. George North got into stride, I think the clarity that I was seeking came. Effectively, you've drawn the distinction that mattered to me. I understand. If you were talking about relocation, it is probably worthy of being looked at differently to if it is an eviction. And the relocation does carry with it an element of other things because you're looking at the discussion on where you're going to go and the effectiveness of that as a site to vend and so on. It might be a useful thing there for Deputy Chief for us to try to make that distinction between how we treat the relocation process. I could see that being bound by time on the part of a time provision being built in for the Crown to have the state, because by the 3rd of November it will no longer be the Crown, for the state to have to yes, the state would have to have a period of time within which to initiate and complete those discussions. Deputy Chief, you following me? Right. As opposed to so that would be a separate form of treatment from how we would treat to an eviction. Now, colleagues, it is 1 o'clock. I am minded that we could break for lunch at this point and come back at 1:45 with a view to working until 3:30 this afternoon. So we would take 45 minutes lunch at this point. Those colleagues online, we will then reconvene at 1:45. Grateful to you all. Thank you.